first virtual oral argument. So,
well, I relate to what's going on because I have no technological skills. If they didn't walk me through, I'd never make it.
mhm.
Okay, now we have one, but we lost the other counsel. One more to go.
Do I need to make my image bigger?
No, you're fine, sir. We can see you. You're fine. Can't say anything except that you're just fine. We can see you loud and see you clearly. We are waiting for, I guess,
Matthew.
Well, they may have the wrong case here. We're looking for Baycare Urgent. Are you on Baycare Urgent?
Oh no, I'm on the Kelly versus.
That's I think that's number 5. We're only up to 4. Okay, we have. Okay, do we have, well, we have one. Okay, your counsel for the appellant with us. Now I just need counsel for the appellee. Aha! We may have electronic success here. All right. When you see happy, smiley faces, you know you had the right panel, right? Right lawyers.
Right, Your Honor.
Okay, let me do some quick housekeeping. Attorney Macris, you represent the appellant, is that correct?
That is correct, Your Honor.
Did you wish to reserve any time for rebuttal?
Yes, please.
How much?
5 minutes.
5 minutes is noted, and I will try to advise you as close as I can to that moment in time so you can make the strategic decision to go forward or to stop.
Thank you, Judge.
You may proceed.
May it please the court. My name is Ashley Macris, and I represent the petitioners Nurse Maria Abuana and Baycare Urgent Care Clinic. We come before this court seeking review of an order by the trial court that denied our motion to dismiss for failure to comply with the Chapter 766 pre-suit requirements that apply to a claim for medical malpractice. And before I get into why this is a claim for medical malpractice, I want to briefly address some of the jurisdictional issues that have been raised by the respondent in this case. Now, it's well established that certiorari jurisdiction lies in cases where Chapter 766 pre-suit requirements are at issue, and the respondent has not disputed this. Instead, she argues that the petition is premature due to the filing of a second amended complaint. This argument is nothing more than a red herring. As an initial matter, the second amended complaint was not properly filed with respect to the medical negligence claims. And I say that because the order that we're here on today granted in part our motion to dismiss and denied in part our motion to dismiss. We are here solely on the allegations on the part of the order that denied our motion to dismiss with respect to the medical negligence claims. So the plaintiff did not obtain leave to amend her claims related to the medical negligence. She was only granted leave to amend to more clearly allege her vicarious claims against Baycare Urgent Care Clinic, but not for the claims of medical negligence. Regardless, we are here on a petition for writ of certiorari. That means—
Well, while we're on the certiorari, make sure I have the dates. The trial court renders an order saying it was dismissed with leave to amend on August 15th of 2019. Is that correct?
Yes, Your Honor.
The second amended complaint was filed on September 4th of 2019. Is that correct?
That is correct.
And the petition for cert was filed on September 13th. Is that correct?
That is correct.
Now, for cert to be granted, certain prongs are jurisdictional. And the amended complaint would render the first complaint a nullity, that it's been in effect legally abandoned. So what would be your material injury through the pending of the lawsuit if the original complaint has been dismissed?
Well, the material injury is exactly the reason certiorari review is proper in these limited cases and medical malpractice cases. And that's because—
I understand that, but there's nothing on the second amended complaint. So if the first amended complaint is the order from which you appealed from, or the one that was reviewed, and it no longer exists because it's been superseded by a second amended complaint, my only current concern is, have at this point, you met the jurisdictional requirements for cert? Because what relief can happen on the first complaint? It's gone. There's no material. What material injury do you have that continues? Now, obviously, you have a second an amended complaint that may have similar allegations, but are we in effect going to be giving an advisory opinion on that complaint without the benefit of argument or ruling from the trial court?
Well, Judge, I would submit that this court scope of review is limited to the first amended complaint, which is why that is what we addressed in our petition. That is the order that we're here
on. And it's dismissed.
Correct. It's been dismissed, and that is the material injury, Judge. The trial court's decision.
How are you injured if you're being sued in that complaint and that complaint has been dismissed?
Because we are only seeking review for the order denying our motion to dismiss. So our material injury as litigants is that we are being required to continue to litigate these claims when the plaintiff failed to conduct the proper pre-suit investigation. So that's the material injury, and that's why certiorari review is proper in these cases. The material injury is the fact that we are still in the case. We are being required to continue in our litigation, and the plaintiff has not complied with the pre-suit requirements prior to expiration of the statute of limitations.
Okay, thank you.
Okay.
I don't want to take up all your time on that. I just kind of struck me as interesting.
Yeah, well, that's why I wanted to address the jurisdictional issue first, because it's something that he raised. I do want to point out that under the invited error rule, I would submit that in addition to not being permitted to leave to amend the complaint on the medical negligence claims, which is what they did anyway, under the invited error rule, the plaintiff knew that we were filing a petition for writ of certiorari. As soon as the order denying our motion to dismiss was entered by the trial court, we were able to seek certiorari review on that because it has to do with the requirements of Chapter 766. As soon as that order was entered, we filed an emergency motion to stay the matter pending the appeal, specifically acknowledging that the court had also entered an order granting our motion to dismiss and that the plaintiff had a deadline to file an amended complaint. We specifically were trying to avoid the exact situation that we're in right now. We filed the emergency motion. The trial court refused to deem it an emergency. We sent a proposed order on the motion to opposing counsel. We never received a response. Then the amended complaint was filed after they knew of our intention to file the petition for writ of cert on these issues. So for that reason, I would think that I submit that the second amended complaint isn't proper anyway. Regardless, the question that we're here today is whether the claims arise out of medical negligence or ordinary negligence. And the allegations in the amended complaint are dispositive in determining whether or not that is true. So with respect to the amended complaint, which is the order on which we are seeking petition for writ of cert, is located at the Appendix 1. And there are multiple paragraphs in the amended complaint that make clear this is a claim for medical negligence. Plaintiffs allege that Nurse Abuana was a medical professional in the state of Florida, was at all times relevant, acting within the scope of her medical profession. They allege that defendant was a professional medical company doing business. They allege that plaintiff was being treated at Baycare when this happened. That plaintiff was seen by defendant, Nurse Abuana, who is a nurse practitioner, who had the professional duty of care to accurately report the medical information provided by the plaintiff. They explain that the purpose of Ms. Shimamoto, the plaintiff, the purpose of her visit was to complain of a lump discovered on her chest. During the nurse's evaluation of that lump, she elicited information from the patient regarding how long the lump had been there and things to that extent. The plaintiff alleges that Nurse Abuana erroneously transcribed and documented the results of this inquiry and examination. The plaintiff alleges that the defendants owed the defendants a professional duty of care, and that the conduct fell below the prevailing professional standard of care of what is recognized as acceptable and appropriate by a reasonably prudent similar health care provider. Those are allegations of medical negligence. There could be no question about it. Even if this court were to consider the Second Amendment complaint, which I would submit is not necessary because the petition should be granted and the entire action should be dismissed with prejudice, the same allegations continue into the Second Amendment complaint. They continue to allege—
The act complained of is the failure to record information correctly. Is that correct?
Part of it is, yes, Judge.
And there was no medical treatment that was based on this failure to record. In fact, it was based on other stuff. At this point, that's all we can tell.
I would respectfully disagree. The allegations—
The act, we are to look at the act alleged in the charging document, forgive me, the complaint. Okay, and the act is the failure to record data causing a lack of insurance coverage. Is that correct? That's the act and the causal relationship.
Essentially, Judge, yes.
And how is that medical malpractice?
So the important thing to note is that this act occurred during the course and scope of Nurse Abuana's evaluation of Ms. Shimamoto.
Well, what you're arguing, it seems to be, and please, I'm giving you an opportunity to correct me if I'm wrong, is that if it happens in a medical setting, it must be medical malpractice. And the case law doesn't suggest that. It suggests that we are to look at the pleading, the act alleged.
That is correct. And I'm certainly not suggesting that just because it happens in a malpractice or a hospital setting or something like that means it's medical malpractice. And there's cases that are submitted by both sides where things can happen in, for example, a hospital setting and be ordinary negligence, such as a slip and fall. Those are things that do not require the professional standard of care or require medical expert testimony. In this case, there will be medical expert testimony required to establish the plaintiff's claims. A jury cannot rely on their collective experience to answer the question of whether Ms. Abuana was negligent.
Why would the jury be able to determine whether or not there was a proper transcription of the notes of the information? What expertise is required? A jury can decide products liability cases. They can decide smoking cases, and cancer causing. What's so difficult about saying, I said A, recorded B? What professional is required except for someone who knows how to take notes? I mean, we take notes. It's not necessarily because of our law degree, but to find out whether I took down a note about another opinion, transcribe the words correctly, don't have to be a lawyer. Why wouldn't a jury be able to understand whether or not this lady did or did not accurately transcribe? That's the part I'm trying to wrap my head around. And I know you still got 4 minutes, so help me out here, please.
Certainly, and that's because documentation for purposes of healthcare providers is a standard of care. I've stated multiple cases wherein there are medical malpractice cases and the alleged failure is failure to document something in a patient's record or failing to review a patient's prior medical history, which is another allegation here, that there were prior medical history existing that Nurse Abuana did not review. In fact, in this court, in 2007, the Torres versus Sarasota case addressed a medical malpractice complaint where a nurse was alleged to be negligent for the exact same reason, failure to obtain a history and failure to document the plaintiff's condition. Both of the medical experts in that case agreed that a documentation standard exists.
No, but in that case, excuse me, the requirement of documentation, there was expert testimony that the documentation was required for the benefit of a subsequent healthcare provider, right?
Yes.
So because the subsequent provider was alleged to have been negligent, in not using a cesarean procedure to deliver the subsequent child. It's like, well, if you'd had adequate notes, this subsequent provider would have used a cesarean procedure, right?
Correct.
That's completely different.
The purpose of that, of citing that, is just to show that there is a reason for documentation. There is a documentation standard of care, and one of the reasons is for subsequent providers.
And the reason isn't so that you get your insurance coverage. I
Well,
mean, the reason for the reason, I mean, the reason that it has to be documented, there are medical reasons that it has to be documented, but here she's saying, well, because you did this wrong, because it's incorrect, I lost my insurance coverage.
Correct, Judge, but the ultimate question isn't why maybe it was or was not transcribed. There's an issue of fact as to whether or not it was accurately transcribed or not. In the First Amendment complaint, they say I didn't say it. In the Second Amendment complaint, they say, well, I said it, but I was referring to something else. That's just like say medical malpractice.
So that's a fact question, and it's not going to require any, I'm with Judge Casanova, I'm not sure how that requires any expert testimony on a medical standard of care.
That's simply because, just like another medical malpractice case involving a radiologist is obviously part of the standard of care is proper documentation of what was discovered during his or her evaluation. Of course, there's a dispute of fact as to whether or not that underlying condition exists or not, but that's the subject of expert testimony. If a radiologist doesn't document something accurately, then that leads to harm. And that's what the plaintiffs allege. This failure to document led to harm. And
led to a pecuniary harm, the inability to pay for a bill.
Correct. And it doesn't, frankly, that doesn't matter. The test that's set forth is codified by the Florida statute 766.106 and the Florida Supreme Court, and emphasized by this court. The focus is on the act from which the wrong arose, essentially. The inquiry is whether the action arose out of medical diagnosis, treatment, or care, and whether it was rendered by a provider of healthcare. There's no dispute Nurse Abuana was a provider of healthcare in this case. So
let me ask you this. There's some decision law out of the Supreme Court of Florida recently followed by Judge Morris on behalf of this court, and I think I was a member of the panel in that case, that says if there's any doubt about whether this case is medical or ordinary negligence, it should go to the claimant. Is that rule apply here?
That is correct. That's been applied throughout the cases that address this issue, and it's our position it's not a closed case. This occurred during her care and treatment of the patient, during her evaluation.
I should have told you, by the way, we're at 15, so I'll do some adjustment, but I want to let you know.
Okay.
Since I asked the question and I got the clock, nobody else does, I'll make an adjustment.
Thank you, Judge.
Go ahead. I mean, I don't want to cut you off. I just want to let you know that you were there in case you want to do the rest of your argument. I don't want to cut off your answer. I'll make the adjustment after you finish your answer. All
right. Thank you, Judge. Now, I mean, I was just going to briefly say that those are when the case is closed, and it's our position that this is not a closed case. The terms diagnosis, treatment, or care, as stated by the Florida Supreme Court, are afforded their ordinary meaning. There is a plethora of case law indicating that when the alleged act happens during the treatment, which is exactly what happened in this case, Ms. Abuana came to the clinic for evaluation of this lung. The transcription is subject to expert testimony, as demonstrated by the Torres case and multiple other cases that I cited in my brief, and therefore the claims clearly arise out of medical care and practice, looking at the allegations in the amended complaint. Thank you.
Thank you, counsel. We will turn to the appellee at this time. And counsel, Mr. Mindrup, the floor is yours.
Thank you, Your Honor. Your Honors, may it please the court. My name is Alex Mindrup, and I am for the plaintiff respondent, Aisha Shimamoto. Ms. Shimamoto will rest her argument on the procedural matters, the order permitting the amendment to the complaint, and will address the other issue. That issue is a simple one: whether Ms. Shimamoto's claim that the nurse incorrectly took down what Ms. Shimamoto had verbally said to her is a claim of medical negligence. This is not a personal injury lawsuit. In this case, there are no allegations or claims for any resulting physical injury. This case is easily distinguished from the cases involving the application of the pre-suit investigation and notice requirements of Chapter 766 for medical malpractice claims. Those cases all involve some kind of physiological injury to the plaintiff and whether the injury was a product of improper judgment and skill in the diagnosis, treatment, or care of that plaintiff. In those cases where the pre-suit investigation and notice requirements were found to be applicable, all involved the physical injury or death at the hands of the treating doctor's alleged failure to properly exercise medical skill and judgment in diagnosing, treating, or caring for the patient. In our case, there is no allegation relating to any decision-making by a medical provider so as to fit within the accepted meaning of medical skill and judgment, nor is there a physical injury to Ms. Shimamoto. Shimamoto pled that the nurse was a medical professional employed by Baycare and had a professional duty of care by the nurse, which undoubtedly the nurse does in the context of her scope of employment. It seemed to be rather scary to see a nurse that did not owe such a duty to her patients. The Baycare and the nurse would have this court believe that this automatically makes Ms. Shimamoto's claim one of medical negligence or malpractice. However, Shimamoto has also pled that the nurse also had a duty to act reasonably and to report accurately what was spoken to her by Ms. Shimamoto. And it is true that Ms. Shimamoto sought treatment, care, and diagnosis as to the lump in her breast. However, the act complained of, that is, inadvertently writing patient reports noticing the lump approximately 1 year ago, does not involve the exercise of medical skill or judgment, so as to meet the court's definition of diagnosis, treatment, or care, nor did it affect her course of treatment, diagnosis, or care at any time. Precisely, there is no medical skill and judgment involved in writing down what another speaks. Baycare and the nurse want to argue that the nurse here made a professional judgment call when the nurse took down what Ms. Shimamoto said as to when she herself first discovered the lump in her own breast. Ms. Shimamoto does not complain of any procedure Baycare or the nurse performed. Actually, she was diagnosed accurately, and after the mammogram results showed the cancer, she underwent treatment for it and cancer-free. The act Ms. Shimamoto complains of did not in any way relate to physical injury, misdiagnosis, or the like. What it did result in is the denial of her insurance coverage on the basis that she misrepresented material facts on her application for coverage, which Ms. Shimamoto claims is not true. This precipitated the lawsuit against Baycare and the nurse. She only wanted that notation corrected to what she herself actually told the transcribing nurse. Nonetheless, Baycare and the nurse argue that Shimamoto's claim should be dismissed with prejudice due to lack of the pre-suit investigation and notice. The trial court below considered this and asked, what will the defendant know by pre-suit notice and be able to evaluate that it didn't already know? In other words, they're alleging it's a misstatement, and it's a mistake. It's a record mistake. It doesn't affect her treatment. It doesn't affect the outcome. What will the pre-suit notice accomplish in this case? It's in the appellate record 6, page 21 of the court transcript. Complained of issue is a mere mistaken notation, not from a doctor to doctor or nurse to nurse, but from the verbal statement by Ms. Shimamoto about when she herself first noticed a lump in her own breast. Baycare wants to argue, or wants this court to believe, any treatment provider who makes a mistake of any kind to a person inside the four walls of a hospital means that such mistake necessarily involves medical skill and knowledge. But if that were the case, then the lawmakers would have made that clear. In their petition, Baycare and the nurse argue that the nurse made a professional judgment call, that Shimamoto reports noticing a lump last approximately 1 year ago, and that Ms. Shimamoto, a layperson, cannot possibly prove her case without the assistance of expert testimony. Specifically, Baycare stated what a healthcare provider chooses to or to not document in a patient's medical record necessarily requires exercise of medical skill and judgment, and a layperson cannot possibly know what information is pertinent to include in a patient's medical record without the assistance of expert testimony. This is not a case of discretion involving medical skill and judgment. This is a case of a scrivener's error. If Ms. Shimamoto had said that she was 50 years old and the nurse wrote down, patient reports that she is 55 years old and the insurance carrier denied coverage based on misrepresentation, would it require a medical expert to opine as to what the patient actually said? Or if Ms. Shimamoto told the nurse that she was born in Tampa and the nurse mistakenly wrote down Toledo and the insurance carrier denied coverage based on misrepresentation, would it require a medical expert to opine on what the patient actually said? In Baycare and the nurse's reply brief, they now concede that no medical skill and judgment is required to transcribe a verbal statement. This is not a case of, in the doctor's opinion, plaintiff had a pre-existing condition case, which would meet the definition of diagnosis. This is not an improper application of medical services case. It does not require medical judgment and skill to write down what another is telling you, and everyone makes scrivener's errors. In cases of medical negligence and malpractice, an expert doctor opines on the correlation between the medical skill and judgment used in the diagnosis, treatment, or care of plaintiff to that of the resulting physical injury to the plaintiff. The Supreme Court in Tanner versus Fortog, in discussing the pre-suit notice requirement held, the statute of limitations in malpractice suit and a med mal suit commences either when the plaintiff has notice of the negligent act giving rise to the cause of action, or when the plaintiff has notice of the physical injury which is a consequence of that negligent act. But here, there is no physical injury. The Supreme Court in 2018 in Towns made it quite clear, for a claim to be subject to the pre-suit screening and notice requirements of Chapter 766, stating that it is required that medical skill and judgment be at issue in the diagnosis, treatment, and care of the patient. The court also said, limiting medical malpractice claims to those that are directly related to medical care or services which require the use of professional judgment or skill ensures that plaintiffs bringing claims of ordinary negligence are not subjected to the complex pre-suit procedures for medical malpractice claims, while still advancing the legislator's policy goals of encouraging early settlements and screening out frivolous medical claims. If this court has any doubt as to the statutory restrictions or requirements that apply, this court has already mentioned in Sacred Heart, the Florida Supreme Court said, any doubt as to whether a claim is for ordinary negligence or for one of medical malpractice should be generally resolved in favor of the claim. For these reasons, the respondent submits that the trial court's order be affirmed. Thank you.
Thank you, counsel. There are 4 minutes remaining for rebuttal, counsel.
Thank you, Your Honor, and I'll be very brief. I just want to point out that there's no allegation in the amended complaint as to why Ms. Shimamoto's insurance coverage was denied. So any argument to that end is not properly before this court. Regardless, there's no sense in minimizing what she wrote down because it was clearly important enough to cause her alleged damages and sufficient to pursue this claim against the defendants. Regardless, the test is not the injury, the test is not the damages being sought. The Supreme Court and this court has stated that the inquiry depends upon the allegations of the pleadings and the specific circumstances under which the injury occurred. These circumstances under which the injury occurred were during Nurse Abuana's evaluation of the plaintiff, and the alleged injury occurred during that evaluation. I do want to point out Judge May's concurring opinion in the Stubbs case, which I did cite in my reply brief. She writes to express the concern about the proverbial slippery slope when we begin to dissect every minute of a medical procedure to determine if it's medical or ordinary negligence. Not surprisingly, the issue arises when the plaintiffs miss the statute of limitations, which is exactly what happened in this case. This is not.
Sorry, I hate to interrupt you, but you focused on when the injury occurred. What do you contend was the injury?
According to the plaintiff's complaint, it was the denial of healthcare benefits.
Right. That didn't occur. Damn.
Pat, you're freezing.
The injury occurred during the exam. No, it didn't.
I apologize, Judge Kelly, I think you froze. I couldn't hear you.
Oh. I said, I thought you said the injury occurred during the exam while she was getting treatment, but the injury occurred later.
And I must have misspoke. I apologize. So the question is the act from which the injury occurred. That's the question. When did that occur? The act from which this occurred during the treatment. So the injury, the denial of healthcare benefits was later. Also point out that based on the amended complaint, the respondent alleges that the only claim is for denial of healthcare benefits. That's not in the amended complaint. They seek damages including but not limited to denial of healthcare benefits. They are not just seeking denial of healthcare benefits. I'll also point out that under the Florida statutes 95.114B, which is the statute of limitations for medical negligence claims, specifically includes death, injury, or monetary loss in the definition of an action for medical malpractice. Regardless, I want to bring us back to the amended complaint. The scope of this court's review is limited to the order. It departed from the essential requirements of law when it required the defendants to continue in litigation when the allegations in the amended complaint, which allege she was a medical professional acting within the scope of her medical profession and owed a professional duty of care, that complaint should have been dismissed with prejudice. And for the remainder, if there aren't any other questions, I would rest on the arguments set forth in my petition and the reply to the response for the remainder. Thank you.
Thank you, counsel. Thank you both. That will conclude this presentation. At this time, let me see what I need to do to let everybody know that you get to depart, and we're going to take a break. We have 2 more cases to go. So I'll go ahead and take care of that matter and see if we can get you out of here, the lawyers, so we don't lose